I would like to call the March 9th meeting of the Morganton Board of Adjustments to order. Everyone has read the minutes. I will accept a motion for the approval of the minutes of the previous meeting.
So move.
Second.
Okay. A motion has been made and seconded. Is there any discussion? All in favor say aye. Aye. All opposed, like sign. The motion is carried. The board is requesting a variance request tonight, and I will read the factors relevant to the issuance of a variance. No matter how well-intentioned and no matter how carefully zoning ordinances are prepared, there are many instances in which the real application of the zoning ordinance creates an unusual problem for the landowner, and it is our responsibility to try to deal with those unique hardships that are created. This Board of Adjustment is given limited discretion in deciding whether to grant a variance. Under the North Carolina state law, this board is required to reach three conclusions before it may issue a variance. These are 1, that there are practical difficulties or unnecessary hardships in carrying out the strict letter of the ordinance, such that the property owner can secure no reasonable return or make no reasonable use of the property. Such hardship may result from unique circumstances related to the applicant's land, and the hardship is not the result of the applicant's own actions. 2, that in issuing the variance, it is in harmony with the general purpose and intent of the ordinance and preserves its spirit. And 3, that in issuing the variance, it secures the public safety and welfare and does substantial justice to the community as a whole. A 4/5 majority vote is required to approve any variance request. The board is willing to hear all relevant testimony, but asks that repetitive testimony be kept to a minimum so that the meeting can move forward. All persons, including the staff, must be sworn in to speak. So, Russ, would you like to be sworn in? Would you please place your left hand on the Bible, raise your right hand, and repeat after me. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Would you state your name, please?
Russ Cochran.
Okay. Thank you. And Mr. Cochran, I would ask that you would explain the variance to the board.
Okay. All right. Thank you, Madam Chair. A variance request has been made to split two single-family houses that currently exist on one lot and two separate lots with a house on each. And if I can get the technology to work correctly. Okay. This is the property that you're seeing at 206, 208 Bynarden. The properties, the history of how this exactly occurred, we're not exactly sure, but the request is to split this property down the middle area that you see. Don't have the ability to for a mouse here, but you can see where the properties are pretty much evenly divided on that particular lot, and the request would be to split that lot 50-50, more or less. The lot is approximately 19,500 and with just a few more square feet in size. It is zoned LID with the minimum lot size is 20,000 square feet anyway. So what I'm saying about that is if these, let's just say this wouldn't happen, but if these two houses were to burn today, you could only build back one of these houses on this particular lot. And I think that's one of the reasonings the request has been made. The approximate size of these two split lots would be somewhere in the neighborhood of 9,800 square feet. Now, having said that, you'll have to understand that there are other houses within this area, the ones that are numbered there, that are actually, as they exist currently, would be smaller than the houses if these two were split on their individual lots. The ones that you have numbered here would actually still be a smaller lot. So that's kind of where we're going. The only, in discussing with other staff earlier, the only The only utility problems that we have associated with this is I believe there is a common sewer tap that is associated with both properties. Each one of them apparently already has their own water tap, so that's not an issue. Once again, this property is zoned LID. The area across the street is zoned MID. The LID that we have currently on this side of the street, once again, is 20,000 square feet lot, minimum size for building one single-family house. In the MID, it is 6,000 square feet. And once again, the request is to split each one of these properties onto their own lot. Are there any questions I can answer this time?
Did you say the water and the sewer was not an issue?
No, sir, the water and sewer are not an issue. The only thing that would have to be done if indeed these properties were to be split, it could be noted on the plat for one of the other that there needs to be an easement of some type, such that if there's ever any issue to be worked on, anything of that nature, that the one having the issue can actually go on the other person's property and fix the issue.
Would the owner of the properties be willing to put in a separate sewer tap for both residents instead of having them to use the same one?
I have not asked that question. You could make that a condition.
Well, it's not an issue, really.
Okay, well, I'm just saying that way, they're gonna be rental properties, and if the people don't get along, well, why are you paying this and why am I not paying this and so forth? And so if that came to fruition, would it be possible to put in a separate sewer tap?
If you decide to approve it, then you could make that a condition.
Well, that would depend also on the property owner, whether or not he would be willing to. If he's not willing to, and we put it as a condition, then it's null and void.
That's correct. Then the variance would not occur.
Okay.
Right. So,
But as I hear you speak to this right now, Russ, though, presently both of these lots are owned by one owner.
that is correct.
So if the owner chooses to part them in the future, for whatever purpose, at that time, the owner could make arrangements to do a separate tap if that were necessary. If the owner were concerned about that in the future,
Yes.
there's nothing that would preclude having a separate tap. But if I'm understanding you correctly, if the owner chose to separate those properties and to sell one or both of them, it could be a condition of the transfer of the deeds, could be an issue in the transfer of the deeds, that the party that didn't have the tap would be able to access it. So we don't need to require that at this point, if I'm understanding it, in order to take a positive action on this.
Well, if you were to take a positive action on this, we would probably handle it by the fact that we would request that a notation be put on the plat that there is, in fact, this is a combined sewer line tap running all the way up there. So if there are any issues, then it can be noted on the actual plat, and that should take care of the issue. Does that make sense?
I think so. For all I know, it's fairly expensive to do another sewer tap. And so I'd be reluctant personally at this point to say, well, you had to have another sewer tap, to require another sewer tap before, we granted the variance, if we were inclined to grant it.
Right.
If a person was buying both of them, it wouldn't be an issue.
Right.
As long as they remain either one owner and a rental or two rentals.
That's right.
Yeah.
That's right. It wouldn't be an issue.
I don't know what the condition of the line is in at the moment, and I don't know, apparently that has been functioning as is for some period of time, and I don't know that it would be even necessary to do anything more than actually require that just be put on a plat, which is not an uncommon way to note that easements and things of that nature.
It seems to me the only way that you could get into trouble is if somebody sold one of the properties without indicating, without taking appropriate action at that point, so that the person who was acquiring the property that didn't have the sewer, found themselves in a situation where, they couldn't, access that sewer, the tap, in order to make whatever changes they needed to make. And you're saying that you
I
can.
agree with what you're saying there.
And what you're saying is you can make, you could attach a condition such that it would be unlikely or impossible for the property to be sold
Well, we can make,
without that kind of,
we
you
we
know,
can do it,
written into it?
we can make it to such that if y'all say, if you were to say to approve this, you can make it a condition that, a notation be made on the plat and all necessary documentation, that shows that an easement for sewer serves both, serves both houses, even though it's combined at this point in time. We can, that's, should be relatively easy.
I'm
So-
just trying to make certain that we won't, 10 years down the line, somebody wouldn't get into trouble.
Would that be on the deed?
That would actually be on the plat. You could note that on the plat, and the plat would be referenced through the deed.
Through the deed?
Right.
And then if the property was sold, that easement on the plat would go in perpetuity, is that?
That's correct.
Okay.
And there's no problem with the, I would presume that electrical connections are such that it wouldn't be that's above, everything's above on that. There'd be no difficulty in accessing, separately for as far as electricity were concerned, and even water. Because water's relatively inexpensive, so.
Water and sewer, water and electricity are fairly ubiquitous everywhere, and you can, if you don't have a pole here or you don't have a way of getting in, our electric department is pretty good about, they'll get you power one way or the other.
Okay.
And the same with the water. 'Cause
And
water
compass,
can be pressurized.
compass cable and
Right. And I can't really
telephone and.
speak for them, but I'm gonna make a leap and assume that both for compass cable and for
Okay.
phone, those areas can both be served.
And I think it's unlikely that there's natural gas or anything like that in the neighborhood.
I do not know that. I did
Okay.
not research that.
At present, does the landowner pay the water and sewage himself and divide it among the two houses, or is it incorporated into their rent?
Well, the only way I can say is some of these questions are kind of leaning towards the property owner. If you want to ask Mike to be sworn in and say a few
Be
things.
great.
Mr. Irwin, would you like to be sworn in, please? Would you please state your name and address, place your left hand on the Bible, and raise your right hand?
Mike Irvin, 402 Winding Creek Drive, Morganton.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
The water bill for the city of Morganton, which each house has their own individual water system, your sewage bill is based on the consumption of water. There's no meter for the sewer. And I've just found out from what Russ told me that there's only one sewer tap. I didn't know that. So as I was thinking about some of the notes you could put on it, I would think maybe a sewer easement for the house where the tap is not located might be one way to look at it, to where if there was a repair to be made to the house that didn't have the sewer meter in front of it, or wherever it is, I'm not really sure exactly where it is, to be honest with you, that there could be some easement, if it had to be repaired, that you could have access to do that. But I don't pay the utility bills for them. Each has their own separate water system and bill and electricity. And I don't see the sewer tap thing being a make or break issue on it, as long as you could put an easement for repairs to where that line would occur if it crossed another person's property. But I'm sure most of that stuff's right out there on the street or the sidewalk, and the city already has the right of way for
Well, now the water bill includes the sewer bill, so that house, both houses have their own water,
That is correct.
so that their amount of the sewer is
They're-
automatically put to that house.
Yeah, there's,
that right,
there's
Russ?
nothing that would cause one house to have to pay the sewer bill for the other house because it's based on the amount of water
Okay.
that you bring in.
Could you explain to us a little bit about the purpose of splitting these two houses?
Well, it's time for to be moving on in the rental estate business. My time's come and gone, and my wife and I are in the process of liquidating a lot of our stuff, and it's difficult to find financing and sell property that has two houses on one piece of land. And a lot of folks are hesitant of it, and then some of the insurance companies are reluctant to want to insure both houses on one piece of land. They like the house to sort of stand on their own property. So I'm kind of grandfathered in because I've had them insured that way for a while, but I know sooner or later, they're gonna send something about how they're not gonna insure them or whatever. So I just felt like it was time to try to clean it all up. And as Russ said, there are several houses, some of them even right next door, that are gonna be in a lot smaller square footage than even when these two are split. So that's kind of why I'm here, is to sort of kind of clean up a little bit of something for whatever would happen into the future, and figure this would be the time to do it.
Mike, how far apart are those two houses from each other? So if you divided, how close would they be to the line? Do you know offhand?
I don't know, Russ, what do you think?
They would be, if I remember I did a measurement, and I think they would have the 10-foot required side setback, both of them.
That was my
would
question.
be, yeah.
And I would definitely put an easement from the property line 10 feet where there could be no encumbrances, or you could deny access or anything like that. That's the appropriate way to deal with that.
Does anyone else have any questions for Mr. Irvin?
Well, just a brief question on the water line. Is there just one water tap? I mean, I'm not sure exactly.
No, there's two separate water taps.
They both have separate taps onto the city's lines
That is
on their own
correct.
property.
That is correct.
Okay, so you wouldn't have any problem in that regard?
No.
Okay.
And like I say, the sewer tap is just for the discharge. There's no meter on it.
Right.
There's no way to evaluate it or what. It's just access for discharge from the houses. So, that's probably the way they made them a long
But
time ago.
sewer's based on what the water you use.
Is there any other questions? Thank you, Mr. Irvin. Is there anyone else who wishes to speak? Okay, if there's no further discussion of questions,
I got a question.
Okay, I'm sorry.
Russ, I want to ask you about, Mike brought up a good thing about the easement versus a notation on the plat. Which way we want to go? Which way would I'm thinking about how to do this.
It would probably be a physical notation on the map, showing like in a dashed line or whatever, however the surveyor actually wants to do it, showing, the area and the width of the easement. And there would probably also be a statement actually on the plat itself saying that this area is dedicated for common use in the event that the sewer failure occurs, some legalese type.
So that the easement would be on both the plat and the.
It would be on the plat, and actually a written block probably actually on the actual plat itself too. So there's a physical notation of it actually on the map part, and then there's a written area down below. You could make the surveyor, could make some kind of notation. He could have the actual, dotted out area showing where the actual easement is, and then showing something like a call out box saying with that particular statement.
And then the
Thank you.
plat with its notations would be referenced on the deed.
That's correct.
Thank you.
What would be do we have Do we have written wordage that would be appropriate for a motion at this point?
I have wording, I'm sure we have a lot of plats that we review and everything like that, and I'm quite sure I can get some appropriate wording for that if you trust me, if y'all trust me enough to do that, or I
Make a
can,
motion.
you know.
Okay.
I have a question or a statement. Since there's no charge for sewer beyond use of water, would there even be necessary to have an easement allowing another or forcing another sewer tap because there's no charge for it?
Yeah.
So why would that even be necessary? Because they're each going to be paying their share based on the amount of water they use.
Don't need a tap, you just need access to it to repair it in the
Well,
event you
yeah.
have a problem.
That's the only
If
thing.
two different people lived in it, say he sold it to, he split those properties and sold it to one person, and then you have sewer line have a problem, you're gonna have a sewer line problem eventually.
Yeah.
So you have to have an easement so you can work on it.
Okay.
That's
Okay.
the whole purpose, to have,
Because the other
So that
person's
no-
gonna be without sewer while you're working on that sewer.
Very good point.
That's right.
But I'm sure we can scare up appropriate language.
well, we need to, before we have them, we need to have that language so we can make a motion.
Or that language
can make a
is not
motion.
available.
Okay,
I'll try it and you can change it if you don't like.
okay, very good.
I'd like to make a motion that the board approve this variance request to split two single-family houses at 206 and 208 Vine Arden that currently exist as one lot into two separate lots with a house on each lot, with the condition that a notation be made on the plat about the sewer situation. Or sewer, whatever you want to call it.
Allowing access in the event repairs are
Yeah,
necessary.
exactly.
An easement on the sewer situation.
Yeah.
An easement, probably a better word.
Yeah, and with the, you know, the possibility that, at some point in time, repair may be needed, something to that effect.
Okay, and we'll make sure Crystal's got that. Crystal can read back what she's got, and then we'll know we've got exactly what we're trying to pass.
I can't, I'm just making notes, but I will make sure that it's in there.
Okay, a motion has been made. Do I hear a second?
I'll second.
Okay, a motion has been made and seconded. Is there any other discussion? Okay, all in favor of the motion, vote by saying aye.
Aye.
All opposed by the like sign. Okay, the motion is passed unanimously. Okay, anyone aggrieved by the decision of the board has 30 days to appeal the decision to the Superior Court of Burke County.
Wait a minute. I'm sure that Louis is going to ask us, we gotta approve the, what do you call it, the hardship.
Oh.
The return, the hardship, whether it's intent and the public welfare. Don't we have to do that?
Do we need to do that, Mr. Venai?
He told us to.
So we're one step ahead.
Okay.
Yeah,
You know what I'm-
Okay.
I do apologize.
Number one, are there practical difficulties or unnecessary hardships?
Yes, there was.
Yes, there were, because
Two houses on the same deed.
not able to get financing or having difficulty with insurance. Is the issuance in harmony with the general purpose and intent of the ordinance?
Yes.
I believe that it is, since.
It's non-conforming.
And in issuing this variance, does it secure the public safety and welfare and do substantial justice to the community as a whole?
Do you
Does
need a
everyone
motion
agree
in
that
those,
it
in the
does?
case of those findings? Or do,
You can make a motion at the end
okay,
if you have all general agreement with all four of them. If all four of you agree that all four of those are met,
Okay.
then you can make the motion at the end.
Okay, let's go on to our next order of business. We have a,
we need to vote on that.
oh, I'm sorry, I thought we, okay.
No, you don't have to vote.
Somebody make a motion about those three.
The four,
There should be four.
I just have
You
three.
used to have three? Okay. Well, you could just make a general
Okay.
variance. factors for the variance. And just make the statement of that nature if you'd like.
Do all members of the board agree that this ruling meets the conditions of the variance request?
Yes.
Yeah.
All four, yes, by acclamation,
Okay.
right?
All in favor say aye.
Aye.
All opposed? That's also carried. Okay, now we'll move to the next item of business. Mr. Cochran, would you like to
Yes.
explain
Thank
that to us?
Yes, thank you. If you'll notice, the second item that we have is a request to request for an interpretation for 510 North Green Street. There is a building located, and if I can get the technology once again to work for us here. Okay. At 510 North Green Street, a request was made to challenge the interpretation that a detail shop, which is what an application has been made for at that location, is not an allowed use in the MID zoning district. This interpretation was arrived at through several different, hopefully logical steps to determine that this, through the new zoning ordinance, would not be an allowed use. And I was approached, it's been about 3 weeks ago, by two gentlemen wishing to, at that point in time, approached me on the basis of having a car wash at 510 North Green Street. After speaking with owners, that was later clarified to be actually a detail shop instead of a car wash. And after a review of the application, let me kind of back up. After I explained and looked in the zoning ordinance and found that a detail shop was not actually listed, I went to a listing on the North American Industrial Classification System, which is a common use among planners when a use is not listed in a permitted use chart, which is a fairly common. It's a use chart that has the uses on the left and the zoning across the top, which tells you, and as a guide, where things are allowed as right by use, with conditions and things of that nature. Since this was not clear at that point in time whether a detail shop was allowed, this was the next logical step for me to do, which is to get into something that would give me a little bit of guidance. And once again, this is the 1997 version of the North American Industrial Classification System. When I looked car washes up in the North American Industrial Classification System, it had under 8.11192 car washes, as an illustrative example, it had detail shops and car washes. So by interpretation with this, the only thing that mentioned either a detail shop, which wasn't mentioned, and car washes, which were mentioned, is under, and I do apologize for this, the camera would not allow us to actually make this a nice, clear, logical, horizontal type picture here for y'all. But under motor vehicle boat sales, and it says with or without outdoor storage, including gas stations and car washes. Once again, the use is listed here on the left, on the top in this case. And the P's indicated, and I do apologize once again that you cannot see much, but you can see some of the P's in the MID. You can see some of the LID being low intensity districts, the MID being the medium intensity districts. But if you'll notice, what you have to have in order for a use to be allowed in a particular district is a P in that particular area where both of those meet the use and the zoning. And if you'll notice for the MID, which is what 510 North Green Street is zoned, there is no P, indicating that is not an allowed use. Now, taking this to the next level, the definition for motor vehicle boat sales includes, if you'll notice at the end, it states all this, it's, establishment engaging in, and it starts to describe it. But the second sentence, second or third sentence here says this definition includes, and it talks about gas stations, service stations, motor vehicle repair, da-da-da-da-da. And the last thing it talks about is car washes. So the logical leap was made that car washes and detail shops being very similar uses, that car washes and therefore detail shops would not be an allowed use in the MID. And that was how the interpretation was reached. Does that make sense to everybody? That's my explanation. So what you're being requested is to say either up or down that my interpretation is or is not correct.
And what are there findings that we have to make?
There
in
are no
that
findings
regard?
associated with an interpretation. It's just a,
So if the issue of whether or not that worked a hardship that, or, wouldn't come into play, or,
No, sir. No, this is just an interpretation of staff, what the staff has interpreted this as.
okay.
A challenge to the interpretation.
And do we have a party that has requested the interpretation?
Yes, Mull Inc.
Okay.
We do have a representative from Mull here. Would you like to speak?
Yes, ma'am.
Okay, would you please approach the stand and state your name and address?
My name is Raymond Moses, 201 Mulholland Boulevard, Morganton.
Okay, and if you would place your left hand on the Bible and raise your right hand and repeat after me, or answer this question. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Everything I just heard Mr. Cochran state and show on video, I agree with him 100%. I mean, that's just the facts right there. There's no argument to it. I agree with everything he says. We were requesting, Mall Incorporated was requesting a determination for, or interpretation of what the statute or whatever you call for the car wash or detail shop. And I see that the only thing you could find listed them as the same thing, basically. It also listed as a service station, also underneath that. Motorboat sales, other things like that, all came underneath the same thing when you looked underneath that. The building was originally made as a service station. That's what it originally was made as. That's what it has always been as. So it would be a hardship to change it from what it originally was zoned as or made as. That's the biggest thing that we're looking at now is for us to go in and change it what it originally was. They changed, apparently, I guess over the last 50 years, they changed the zoning on it because the city inspector came in with, I met the 2 city inspectors in there, and they told me this was all set up for that. That's what the building was set up for. That's what this drain is for right here, for you to work on cars or detail cars or whatever might be in this spot right here inside the building. So I guess maybe our confusion is, whether you call it an automotive service shop, a detail shop, a car wash, a boat sales place, because all of them fall underneath that same definition. Why would the building that was approved by the city of Morganton at one time not be approved anymore? The building has never changed. The property has never moved. The building's never moved and came back. So maybe that's our confusion then, if it doesn't fall under that, what it was built for and what it was approved for.
Is it appropriate to ask questions?
It is.
And I don't know that you're the one to answer this, but if I'm understanding this correctly, though, the only issue before us tonight is whether or not Mr. Cochran's interpretation is correct. You may have other recourse. In fact, you may have other recourse in front of this board in terms of trying to, to get some, an allowable use there which would be precluded by the new zoning. But that's not what's before us tonight. I don't know that this board has the authority right now, for example, to grant a variance, because that's not the issue that's before us. He needs,
That's correct.
some of the questions that he's bringing before us, unless we find that you're in error, and he's saying, based on his own interpretation of this, you're not in error. He needs to come forward with another request, not tonight. You need to go through the process, come forward with another request in order to get hopefully to get the relief that you would like to get.
That's fine, I understand.
Am I
Yes, sir.
understanding this right?
That's correct.
Yeah.
And we have an attorney here. That's the only issue that's before us tonight, is whether or not the interpretation is correct. He needs to bring another request if he desires to do so.
Right.
For relief.
There
But
are,
it wouldn't be based on the correctness of his interpretation. Unless we, in spite of the fact that you agree with him.
I agree
We
with
still
what I
think-
see on
we still-
paper.
we still
That's
think
what I'm
he's in
saying. I agree
error.
100% with what Mr. Cochran stated and what he showed us on paper. I agree that it says it's the same thing
Okay.
in black and white right there. That's what it says. I agree with that.
Louis?
Just so there's no, if I might, no misunderstanding. I understand what Mr. Lindsay's saying, but of course, the variance process would not be applicable here because the use in question is not permitted in that district.
Okay.
You can't use a variance to change that. There may be other,
Well, just as a matter of explication, there would be potentially some other forms of relief,
yes.
but we don't know what those are right now.
Well, they could be a rezoning. They could request rezoning. So there are other avenues. But tonight, the only request is for this interpretation.
So I guess to understand what it says in here, the interpretation, we could also ask for, I guess, with the interpretation right now, it just goes with car wash and we're just here to determine the interpretation of between a car wash and a detail shop. That's basically what we're here for.
It's pretty clear.
Yeah.
What we're here tonight is to challenge, Mole Incorporated made a challenge to my interpretation of of saying that a detail shop is not an allowed use in the any MID area. So it would not only apply just to y'all, it would apply to any MID area,
Who made that challenge?
Mole Incorporated.
Oh, okay, yeah.
Yeah.
And he's representing them tonight.
That's correct.
And he's saying now, he's no longer challenging that.
Wait a minute.
No, I agree with what he just showed me because
He's
we never
agreeing
saw
with
that
you.
before.
Okay.
That's what I'm saying. I mean, I agree with what I see right here. I can't argue.
Okay.
There's no reason to argue that.
So what he's doing tonight is agreeing that he's not asking, he's agreeing against his own, request.
That's right.
Essentially, yes,
Yeah.
sir.
Okay.
What did you have, Mr. Redder, did you have a question?
When I was doing research with this, with Russ and his office, we discussed this at length, and it was my understanding that it came up a service with no outside storage would be under the MID zoning and would be okay to do it that way. So you could put a detail shop up in there.
Right, if that was determined that was the use versus a.
Well, if you keep on reading in that information that you had there about the interpretation of this, that's one of the interpretations.
That was just.
Service with no outside storage building would be under the MID zoning, which would be okay for him.
Right.
It listed a whole bunch
that
of,
was-
excuse me,
that
it
was-
listed
Yeah.
a whole page and a half of all the things you could do and couldn't,
Right.
could do. And then it said in small notes there that and I wrote it down because I thought it would be, be okay. Why don't you agree with that? I'm talking about Mr. Lindsay down there.
I think it's a straightforward reading here.
It's an interpretation.
Well, I think it's a very straightforward interpretation.
I don't agree
Well,
with that.
it says, to my thinking, it says car washes. It doesn't mention detail shops, and detail shops are not the same as a car wash. There's a difference there.
It's a, s-
Question, outside storage, if they have 4 cars waiting to be detailed, is that outside storage?
no, it's a-
If a car's left overnight to be done the next day, is that outside storage? Even though it's not their property? Does that come under their control if someone says, okay, I'll pick my car up tomorrow when you can get to it? Does it come under that car wash's control, or is it still under the owner of the car's control? Now there you're getting into an insurance question.
If it came under, if that situation applied as being storage,
That's what I'm
then,
asking.
then every body shop, every
That's right.
place in that,
In
would
insurance
qualify.
wise, if a property is left to be worked on and it's broken into, who is responsible? The insurance policy of the, body shop, car wash, whatever, or the individual? Is the individual relinquishing his control to that property? So it's not an easy yes or no question. Because you go to any of the detail shops, there are generally cars parked there overnight because they're either busy or the weather's bad. So you've got a question there.
Detailing is an extension of car washing, or vice versa.
Say for,
Detailing is an extension of car washing.
Yeah.
It's cleaning.
but who has control of the property?
I agree with you. I think Russ's interpretation is very straightforward and very compelling. That's not to say that there isn't other relief available, but it just seems to me that, you know, that it's appropriate to say that detailing would fall under car washing.
But, excuse me, like Mr. Rader said, we looked at the definitions and stuff, and that's why I checked with the city inspector, said, look, for us to be able to do this, for us to not break whatever the statute or whatever the zoning was, we have to do everything inside. And that's why I want to make sure with the city inspectors that it was okay to do everything inside, and we had everything set up for it, and that's why he said, yeah, this is already set up for it. And that's why when he mentioned that, that's why I said, well, we agree with that, but apparently we got kind of cut short with the difference between car wash and detail shop.
and then I may add to that, if I'm not, you correct me if I'm wrong, Mr. Moses, that building is structured so that you can actually wash cars in there and have its own drainage system.
That's exactly right.
Where some of the detail shops in our city don't have that, which filters out some of the.
Right, we have a sand
pollutants.
filter, we have basically a sand filter drain that goes right there. Like I said, it's already designed, the city inspector's already been out there to look at it and everything. Everything is done, made to be done inside.
But see, that's not the question.
Well, I'm just
The
saying.
question is storage.
Well, storage is one question.
Yeah, well, that's what I'm saying. That's a question I raised.
Something that might give a little bit of insight to this, the way this was previously zoned under the new zoning ordinance, and we have a new zoning ordinance as of the first of the year. The way this was previously zoned was NB. Car washes were allowed in ENB.
Yeah.
That's
It
your
used to be a
issue.
small engine repair.
It used to be a small engine repair.
Yes.
That particular use has been out, I mean, this is just my recollection, it's been out at least 2 years, maybe 3. But I understand that was there for some number of years. So the new zoning ordinance does not allow, once again, if my interpretation is found to be correct, car washes, which are pretty, that's pretty much, that's somewhat spelled out at least. And therefore, maybe by extension, if you did approve what I had said and agree with me as far as the interpretation, then detail shops, car washes would not be allowed as they are listed in the current zoning ordinance. They would not be allowed in any MID location anywhere in the city. And that, by extension, would be probably with detail shops if you're agreeing with what I say. So car washes are somewhat clearly spelled out. Detail shops, by extension, would not be therefore allowed also in the MID. Now, that's really kind of the question as of right now.
That's the,
And if there are other car washes slash detail shops located currently existing in MID zones, if something were to happen to them they were to close up, they would not be allowed to reopen as that same kind of business also.
That's correct. Usually it's a 6 month period.
Wouldn't they be grandfathered though, if they were there in existence prior to the new ordinance, new zoning?
Yes, as long as they keep
as
operating.
long as they keep operating. If they've been operating
That's what I
there,
was gonna ask him.
they could continue
Yeah.
operating that way. That's their problem right now.
They came in after January.
They came in after January with this. But that doesn't go to the basis of Russ's classification. And once you start saying, well, it's detail if you do it just inside, or you can do detail as long as it's just inside and so forth, it's going to become very convoluted, in terms of leaving the record for the future. None of which is to say that he may not be able, and Mull may not be able to get relief and say, that we need, we want to do some other things, and, which we were previously able to do and which won't be disturbing to the neighborhoods and all those kinds. But I think my personal feeling is that Russ has made a very good reading here, and it would be good to start with that and determining, what further course should be taken, when they decide how they would
Or
like
they
to
could come back and ask for an exception on the rule.
They could, there are a number of different ways they could go, but that, but Russ, I personally feel like Russ has made a very compelling, judgment in this regard. It's clear,
The two ways you get a use at a
that's just right, just me.
The two ways you get a use at a location, either number one, it either is a permitted use. Well, in this particular case, it's either a permitted use or it's interpreted as some type of permitted use at that location, pretty much. This one would affect, this is a determination and interpretation that would not only affect this particular location, but it would also affect, once again, any MID area in the entire city, having to do with, once again, by extension, detail shops, if you agree with my interpretation. So it is, while it is going to affect this particular property, it is a larger question also.
Yeah, otherwise you're gonna have people saying, well, we're no longer a car wash, we're a detail shop. And a detail shop is just thus and so, and people won't understand what it is. So it may be that you've raised an issue that's gonna have to be addressed by, a number of other people, going forward.
And I included the services, the indoor services, is kind of an illustration of, just to kind of give y'all an option as to see what else might be anywhere near or close to this type, the particular type of use or request that they're making. That was more of a kind of an illustrative type purposes.
Okay, so our job tonight is to vote on whether we agree with your interpretation. Is that correct?
That is correct.
So I don't see that a motion is called for in that respect, just a simple vote. Is that correct?
Yes, a simple
Okay.
vote.
Is this a majority vote, or how does it work? Does it need to be unanimous? How does it work?
No,
Majority?
majority.
Simple majority.
We have,
Right, it's
Okay,
not a
this is-
variance. Right.
This is not a variance, it's just a vote on whether or not we agree with Russ's interpretation.
Wait a minute.
Okay.
Now, Russ, I'll tell you something. If it's gonna affect all the MID zoning, then I'm going back to my original note that I saw up there in the office. It's a service with no outside stores, so it's gonna affect all of them, past, present, and the future. If you do that, then it's okay to have it.
Once again, one of the ways it can be, this can be relieved is that, this might be another way of doing it would be to go back to the city council, through the planning board, and say that this, auto detailing and car washes should in fact be allowed in EMID.
yeah, that the current zoning is too restrictive in that new ordinance.
But however, anything in the past that's already set up is grandfathered.
That is
So
correct.
it would
As
not
long
affect
as
those
it's
at all,
still
and
in-
it could change hands as long as it's staying in that operation.
That is correct.
So the only thing it's going to affect is anything in the future, which could then be said yes or no as to the location.
Well, if it was an MID.
That's what I mean.
Yeah.
In other words, then they could make an exception for this or that. But right now, anything that's already in operation is grandfathered.
Anything that's in operation at this current time, yes, is grandfathered. It would be considered a non-conforming use.
And so they would go to the planning and zoning, they wouldn't go to the city council, would they? Go to planning and zoning?
Go to the planning and zoning and then to city council.
I think what would happen is that they would sit down with staff and
Yes, that would be
Try
the
to-
first thing.
try to figure out an appropriate way to go forward, you know, if they can. And I personally feel like there are ways that they would be able to go forward, but I think just my personal feeling is Russ has made a correct, you know, interpretation. It looks to me
Can
like.
I ask a question? This is just a question. Would I be able to find out the other locations that have car washes or detail shops, if they're MID or whatever like that, be able to find out on that? Would I check with zoning? Okay.
You
That's-
can
I
that's-
think
combine.
they'll be, I think my personal feeling is, I think they're gonna be interested.
Yeah.
They're gonna wanna find out if, whether or not they ceased operation,
Well, like I told Mr. Radar from the beginning, my thing is about paying attention to detail, and that's what I'll find out, to see if
Yeah, I
everything
think- yeah.
is right.
Yeah, you
know
can,
what I
you
mean?
can come by. Yeah, we can go over all of that.
Okay.
but if you accept the validity of this language, I think Russ has made my personal feeling is that Russ has made a correct interpretation. Having said that, I am very sympathetic.
Yes. He's gonna have to go and check with this
Yeah,
and
we
do
need to-
that, and then come back and say, ask for an exception of that. If the city council does not change the wording, then he's gonna have to come back and ask for an exception to the zoning for that one location.
Ask for some other form of relief, and I think it's sitting there. I think the other forms of relief are there.
I think the planning and zoning board will give him the relief. I really do.
Well, that may well. Do you need a motion?
No, I need a vote.
A vote, okay. The vote is gonna be
All right.
what? State what the vote is.
We'll now conduct a vote on if you agree with the interpretation made by Mr. Cochran of this this definition. If you agree with his interpretation, vote aye.
Aye.
Okay.
And there are, and there are no no's, if I'm correct.
Are there any no's?
No, okay. So it's an it's a
All right.
unanimous.
The unanimous vote is that we agree with Mr. Cochran's interpretation. So,
Thank you.
thank you,
very
and,
much.
Well,
we will-
anything further, then he'll have to take a few extra steps and then possibly come back to us then.
Well, he's doing a public service.
Yeah.
we
Not
wish
just
you
you.
luck and look forward to your progress, seeing how your progress will go.
Thank you.
Thank you. Is there any further business to come before the board at this time? As there is no further business to come before the board at this time, this meeting is adjourned.
Thank you.
Thank you very much, Madam Chair.
Thank you
Thanks,
so
Louise.
much.